Welcome to our discussion with Sarah Isgur, a staff writer at the Federalist and a brilliant person on all things Supreme Court. We are excited to have you with us today and wanted to discuss what has happened in the most recent term of the Supreme Court. Could you give us the Cliff Notes version of what happened in June?
So the big thing is that Chief Justice Roberts really became the swing vote on the court, and everything that came out of that change. So you had Justice Kennedy as the swing vote for a long time on the court. He retired a couple of years ago. We have a new court with Justice Gorsuch and Justice Kavanaugh. This is sort of the first full term with everyone set to go. And the result was, oh my gosh, the Chief Justice is now in the center, and all that comes out of that. And it's a big deal to have the Chief Justice as a swing vote. It hasn't happened for 50, 60 years. The Chief Justice gets to assign the opinions to other justices. So if he's in the majority, he gets to say, you, Justice Gorsuch, are writing this opinion, or he can assign it to himself. So that's a pretty big deal to have both that power matched with also being the vote in the center of the court. You combine those, it made for a really interesting term for Supreme Court nerds like me. But also just, if you're into knowing what the laws are in the country, pretty interesting on that front too.
Well, and was this expected, or was this a big surprise? Like, have you seen it trending this way?
No, this was pretty expected. The Chief Justice in previous years had voted pretty reliably conservative, but there had been moments where, I don't know how else to describe it other than as an institutionalist, meaning, for instance, go back to the Obamacare case that came up in 2012. Was Obamacare constitutional or not? And the Chief Justice ended up being the swing vote on that case, where he said that because it was more like a tax, it was constitutional. A lot of people felt like that was an odd legal outcome to find because there wasn't a whole lot to lead one to think that it was a tax. And in fact, that's a case we need to talk about for the upcoming term because it's coming back up to the court now. But what a lot of people read into those tea leaves was that the Chief Justice in an election year on Obama's signature law, where the president had said that he was going to run against the Supreme Court if they struck down his law, that he decided that it was important for the Supreme Court as an institution and for its credibility to uphold that law. And so he found a way to do that. And so that's sort of the Chief Justice as an institutionalist. And so then when we got Justices Gorsuch and Kavanaugh on the court, I think, it wasn't shocking that he would then have moved to the middle. And I think the biggest way that we saw that this year was on the abortion case out of Louisiana.
And do you remember Justice Roberts' confirmation hearing when he said that he wanted to be an umpire calling balls and strikes? That's really what I remember from that confirmation. And I feel like it's interesting how that's foreshadowed kind of the role that he's trying to cement for himself. Do you get that sense as well?
He's definitely calling balls and strikes, but perhaps the question we didn't ask him at the time was, what is the game we are playing?
Good point. So you mentioned the abortion case. Could you talk a little bit about a few of the cases that came down, the decisions that came down?
Sure. So the abortion case was Louisiana had passed a law about an abortion restriction, saying that doctors who performed abortions had to have admitting privileges to a nearby hospital. And there's a lot of discussion over whether that would have even mattered in Louisiana, et cetera. Forget that. Facts, right? They barely matter. Go back to a previous case called Hellerstedt. Texas had passed an incredibly similar law. Again, there's some discussion over how similar the law actually was. Again, facts, who cares? The point is, Texas had a really similar law, and the Supreme Court struck that down 5-4, with Justice Kennedy being the swing vote in that case. Do you know who was in the dissent? Chief Justice Roberts. And he said that he would have upheld Texas's restrictions on abortion, including that doctors had to have these admitting privileges to a nearby hospital. Fast forward to this term. Louisiana's up. Very similar law, but we have two new justices replacing Justice Kennedy. So surely we have 5 votes to uphold Louisiana's law. The Chief Justice switches sides, and he votes 5-4 to strike down Louisiana's law, saying that because they had made that decision in the Texas one, he wanted to maintain that precedent, if you will. And so he struck down Louisiana's law so he could match the Texas outcome, even though he had voted in the dissent on the Texas law. Now, here's what gets really messy. He said he was in the dissent.
That's not messy enough, right?
Right? So he was in the dissent on that Texas one, and he said that he therefore didn't agree with the test in the Texas law. So we're actually going back to the 90s case called Casey, which is sort of, everyone talks about Roe, but actually the Supreme Court's test on abortion is Casey, and that's the undue burden test. So it was a big deal on where the Chief Justice ended up. It was a big deal on just, abortion restrictions in general and what states are going to be able to do. And a really big deal to determine what the test is going to be for those future restrictions. And the test, as it looks right now, according to the Chief Justice, who is clearly going to be that fifth vote, is, does the restriction place an undue burden on a woman's right to seek an abortion? What does that mean? We're still not totally sure. So that was one of the big cases this term. There were a few other, what we sort of refer to as the culture war cases. Transgender and sexual orientation is now protected under Title VII. So for a lot of employers, the majority of employers in the country, they cannot refuse to hire someone because they identify as transgender or as homosexual, and they can't fire someone for that. That was a big deal. Justice Gorsuch was in the majority on that case. Again, you may care about the issue, but even if you don't, from a legal nerd perspective, what was very interesting is that the conservatives had an all-out food fight over that case. So you have Justice Gorsuch saying that he's applying textualism, that the text of Title VII says that you can't discriminate on the basis of gender, and that when you're firing someone for instance, being transgender, you are firing them because they don't match your stereotype of what female or male should be, and that is a form of gender discrimination by the text of Title VII. Well, textualism is considered conservative, right? I mean, that's how conservatives read the law. So then you have Justice Kavanaugh saying, no, that is not textualism. Let me tell you what textualism is according to, my version of textualism. And he has a whole dissent on that. And then you have Justice Alito coming in and saying, textualism, bullshit. It should be originalism. And here's how originalism should be applied. So all of these are conservatives arguing over different methods of conservative legal interpretation. And so if you just want a primer on how conservative legal thought works right now in the country and the intra-family fight going on, it was fun. It was feisty. I mean, Justice Alito's dissent is, to use the emoji, like fire emoji, fire emoji, fire emoji.
That one would be fun to be back in law school to discuss, wouldn't it, Sarah?
Yes. And then there were a few other cases that were of a lot of interest. The president's financial records and whether Congress can subpoena those financial records, whether a state prosecutor can subpoena those records. And here we are several months later. We still don't know because both of those were sent back down, but they were 7-2. So that was sort of a good, Chief Justice Roberts would like that because it means the institution of the court is not getting pulled in partisan directions, but instead there was a lot of consensus about the outcome of those cases. DACA, whether dreamers get to stay in the country. The president had tried to wind down the Obama administration's DACA program. And Chief Justice Roberts in that one said that basically, due to a paperwork error, no, you could not wind down the program yet. The Trump administration will have to redo the paperwork, if you will. And as one friend said, do better, Trump administration, do better.
Going back to the first case and Chief Justice Roberts, how rare is it for a Chief Justice to play that role? And who do you think he looks to historically for inspiration for that?
Oh, that's such a good question. Who does he look to historically? I think that the Chief Justice, first of all, if you're on the Supreme Court, you've got a pretty healthy ego. So in general, I think that, they're charting their own path. This is the Roberts Court, after all. That's what we call it. And so, I I bet he would have an answer to that, but I bet in his heart of hearts, he's like, I'm my own man. I'm charting my own way. As I said, it's rare for a Chief Justice. Right. It's rare for a Chief Justice to be the swing vote. The last time that happened was during the New Deal, during the second Roosevelt administration. So, I'm sure that the Chief Justice has some judges in mind, but he's in a unique position, and I think he, to some extent, enjoys that.
Well, it's interesting to think what President Bush would have thought of all this when he appointed him, and kind of turning to appointments. That's been a chief victory that the Trump campaign and Trump administration has promoted, is appointing 2 Supreme Court justices. How do you think they're talked about inside the White House these days?
That's such a good question, because obviously there were a lot of people very upset with Justice Gorsuch's opinion in that case I was talking about on Title VII, but he was still applying conservative methodology to that. Even so, you have senators like Josh Hawley, an ally of the Trump administration, a Republican senator from Missouri, saying that the conservative legal movement was dead now. And Adrian Vermeule, a conservative-ish professor at Harvard, saying that we need to scrap the conservative legal movement as it's been understood since the start of the Federalist Society in 1982, and instead adopt what he calls common good constitutionalism, which in short is more like outcome oriented. What is the conservative outcome?
What we're trying to get away from?
Yes. So the exact opposite of what the conservative legal movement had been for the last 30 years. But you have a Republican senator who's, a very talented lawyer in his own right, and a Harvard law professor saying, we tried it, it didn't work, forget process, this should be about outcomes now.
And that's more or less what the left says, right?
Yes. And that's what, legal outcomes had been for a really long time. You think back to, actually, this is like an ongoing fight. So we talked about Title VII and the text of that. So on the one hand, it's not an outcome that conservatives liked. They don't want employers to be restricted in firing sexual orientation or transgender people. They didn't like that outcome. Fine. But textualism was applied. You go back to the original affirmative action cases in the 70s, and their reading of Title VII was basically like, well, yeah, it says that you can't hire someone on the basis of race. But if it's beneficial hiring on the basis of race versus discriminatory hiring on the basis of race, well, that's fine, despite what the text says. So a lot of conservatives, though, have noted that using Justice Gorsuch's reasoning in this latest case means that also you're going to have to go back and revisit affirmative action, an outcome the conservatives would like. So it's really hard to say. I mean, there's a reason that the conservative movement was about process and not outcome. If you want to undo that and make it about outcome, then everyone gets to have the outcome that they want when they're in power. And in general, the appellate courts in particular swing pretty wildly in new administrations as judges retire, et cetera. And they dictate a lot of the law around the country. Very few cases get to the Supreme Court, like way fewer than 10% that they even ask the Supreme Court to hear, and that number's been going down. So it's a dangerous thing for the conservative legal movement to decide that it wants to chuck the process argument in favor of outcomes, because come the next administration, you could have very different desired outcomes.
So where do you think it'll all land? Are we going to see more changes in the next term, or what are you anticipating?
Well, we've got 2 big cases in the next term so far, which is one, another Obamacare case. So I mentioned the tax argument from the 2012 version of the Obamacare case. Well, so then Congress zeroed out the tax. Well, the only thing that made Obamacare constitutional was the tax. And now the tax doesn't exist anymore. Is Obamacare now unconstitutional? That's the question. And actually, it's a really interesting legal question.
I feel like I don't remember many days when Supreme Court decisions came down, but I remember when that Obamacare decision came down. That was a huge deal.
I absolutely remember where I was, in part because, you're having people run out with that case and they got it wrong, because the first few pages were like, this isn't constitutional, this isn't constitutional, this isn't constitutional. And you get to the end and it's like, But if it's a tax, it's constitutional. I think it is, so it's all constitutional. And everyone was like, whoa. So that's up at the court again. A big deal. But most likely, what the court will say is, with Chief Justice in the majority, okay, they got rid of the tax. That does make the individual mandate, for instance, unconstitutional. But Congress zeroed out the individual mandate anyway. So we're just going to sever the individual mandate from the rest of the law and keep the rest of the law. So legally, this will be a big deal, but in terms of affecting anyone's life, it will be a zero deal. It will affect no one, potentially. Another big case that's up is whether adoption agencies have to adopt to same-sex couples. This has been a long-running and growing tension within the court of, on the one hand, same-sex rights, LGBTQ stuff, and on the other hand, religious liberty questions. And what we've seen, at least in this past term, but even going back several terms, Masterpiece Cake Shop being a good example, is that the court massively expanding LGBTQ rights and massively expanding religious liberty rights as well. And so the two growing at the same time. And that's going to be really interesting because this is a case where, once again, those are coming into clash. And what will the court decide to do with that? And it's out of Philadelphia. So that'll be interesting.
You mentioned religious liberty. Could you talk about the religious liberty case that came down last term?
Sure. There were actually a couple. So the biggest pure religious liberty one was called the ministerial exception. Basically, when can not just churches, which churches can hire and fire whoever they want. That's pretty well decided. But what about like a school that's Catholic affiliated? They're not a church. They teach kids who aren't Catholic. Lots of people send their kids to religious schools because it's closer or it's just a better school. What can they do? So on the one hand, if they have, church each morning, clearly the person who's standing up at the pulpit is much more like a minister at a church. The school can decide that they want a Catholic minister for that and therefore can discriminate against some people when it comes to picking that person. But what about the janitor? Surely the janitor is not a religious figure at that school, and so employment discrimination laws can apply to that janitor. You can't fire the janitor because he's Black or white or Hispanic. Okay, that's easy enough. But then we have all of these people in between. What about a high school teacher at a religious school who teaches religion? Seems more like the minister. What about an elementary school teacher who teaches no religion and is the gym teacher who's in charge of helping the kids play dodgeball? Maybe closer to the janitor. And so what the Supreme Court was deciding is basically elementary school teachers who teach the same students all day. They teach math, they teach English, but they also teach religion. Is that more like the gym coach and the janitor, or is that more like the high school religion teacher and the minister? And it's a big deal because it determines whether employment discrimination laws apply to these religiously affiliated schools. And the Supreme Court said, yeah, we're siding on religious liberty here. If it's a coin flip, you decide that the school has the right to say that that person is a minister in their religion, and therefore employment discrimination laws don't apply. They can not hire someone because they're Jewish and it's a Catholic school, and vice versa. But the rub here that most people, I think, are surprised about is that it's not just that you can discriminate on the basis of religion. Either all the employment discrimination laws apply or none of them. And so none of them apply, meaning you can fire someone because they have cancer or because of their race or their, national origin. And that's a pretty big deal for a lot of people because there's a lot of people employed at these religious schools across the country.
Interesting. I'd now like to turn to one last question, and then we're going to open it up to audience questions.
Yeah.
Which is, we are in 2020, an election year. What impact do you expect the court or recent court decisions or upcoming decisions to play in this election?
Traditionally, Republicans have been Supreme Court voters and Democrats have not. When you ask voters whether they are voting, like what's their number one issue, always Republicans have led Democrats by about 10 points on that question. It's a much, much bigger deal on the R side of things.
Why do you think
But
that is?
2020, because Republicans have made it a bigger deal. They've educated their voters over decades that like the court is where like your last bastion.
Really?
The Democrats have Hollywood, they have academia, we have the courts. Like this is what we need to have. And for a long time, Democrats just really struggled to get their voters engaged in that, in part because the court was pretty down the middle. It was pretty split 50-50 on a lot of things. With the confirmation of Justice Kavanaugh, we have seen a shift in those numbers, and that more Democratic voters are enthusiastic about the Supreme Court. It is still not to the level of the Republicans, and it'll be interesting to see in exit polling this time whether that became real, in part because right now, at least, maybe that was a thing a year ago when Kavanaugh was fresh in people's minds. But at this point, you have the pandemic, you have racial tensions around the country, and you have just a visceral loathing of Donald Trump on the left, all of which contribute a lot more to enthusiasm than a discussion of the courts. You're also not seeing Joe Biden bring it up very often. And it's hard to get people jazzed about the Supreme Court and a potential vacancy when the candidate himself is not talking about it much. I think you'll see it come up at the debates. I think particularly the vice presidential debate, you can see it come up with Senator Harris because she's an attorney and a former attorney general in California. But
and she was on the committee. I thought we'd be seeing it more from her right now.
Yeah, for sure. And we're just not, because there are other issues that are more important. And just to be clear, when you ask voters what their number one issue is, it is and has always been the economy and jobs. So we're talking, it's still lower down even for Republicans. But, Justice Ginsburg, it would be difficult to imagine her making it through another 4 years of any president's term. And so you also have Justice Breyer, who is getting up there in years, and you have Justice Thomas, also age-wise. You also have Justice Alito, and there's been some rumors that he's just kind of sick of it. So there are potentially, 2 to 4 openings coming in the next 4 years, and who will fill that matters a lot to some number of voters.
It's funny, Sarah, I'm not sure if 2020 can handle another Supreme Court vacancy as another issue, right? 2020 is sort of maxed out, and
we're maxed out. I mean, we had the murder hornets, we're done. So there's a sign in DC. You and I both live in and around DC, and there's a sign that says Ruth Bader Ginsburg lives less than 5 miles from this sign. Please put on your mask.
That's funny.
That always cracked me up.
Well, let me turn it to some viewer questions. One of my colleagues is texting them to me. So first one comes from Grace from Cornell. She asks, how much influence do judges have over each other when discussing and debating a case? Or are the judges' feelings towards cases mostly based on their own political and Supreme or court views?
That's a really good question, because the answer is most of the time, a justice knows how they're going to come out on a case. They've had similar questions before. But absolutely, they change their votes. It doesn't happen that often, but it happens more on these very tight cases. And so the cases that you're most likely to hear about are the cases where justices were most likely to change their mind. How that happens. So right after they hear a case, let me back up, actually. So the court accepts a case. They get briefing on the case. Their clerks will prepare, some things for them about the case so they can read up on it and go into question time really prepared. After they hear from the advocates during the question time, they have the briefs, they now have the questions, they go into conference with just the justices and they discuss the case. And that's where it's like, I'm on this team, I'm on this team, they take a vote, and then the opinions are assigned. But what happens after that gets really interesting because, Justice Gorsuch gets assigned the opinion and he circulates that opinion to the people on his side. And let's say there were, 4 other justices. It was going to be a 5-4 case. And one of those 4 justices sees it and is just like, yeah, wow, that's way less persuasive than I thought it would be. And I'm seeing a draft of the dissent. I just think they've got the better argument. You can have justices not just change their minds, change their votes on a 5-4 case that the entire decision switches the other way. You also can see justices maybe less dramatically, but really important for the future of law, maybe they don't change their vote. Maybe that case stays 5-4, but they still don't find the majority's reasoning persuasive, and they decide to write a concurrence of their own, which means that that majority opinion, the outcome is binding on the court, if you will, but the reasoning is now really fractured. And what lawyers look for is like, wow, that means it's actually still not really settled law. And so that means you're going to see more cases on that topic, most likely coming up in the years to come.
Thank you. And also, what about more broadly, beyond the Supreme Court and Supreme Court justices? What about appellate judges?
Yeah, so that, appellate judges hear so many more cases that oftentimes they are getting sort of novel questions to them. And they both look to their own circuit where they sit, but they also look to other circuits. Now, the other circuits may not be binding on them the way that their own circuit decisions are, but that's sort of how, states are laboratories of experiment. The circuits are laboratories of legal experiment. And so you may have the Sixth Circuit decide a case one way, and the Fifth Circuit looks at that, and some judges on the Fifth Circuit, and sometimes they'll say, you know what, I think the Sixth Circuit had it right, we're going to go the same way. And other times you're going to have the Fifth Circuit say, those dummies on the Sixth Circuit have no clue what they're talking about. We have the exact same facts, we're coming out the other way. And so now you have, 3 states in the Fifth Circuit under one set of law, and then you have 5 states in the Sixth Circuit, however many states are in the Sixth Circuit, under a sort of a different set of laws. Well, that's really messy, because if I move from Texas to Kentucky, now I have no idea what the law is. And we call that a circuit split. And those are the cases most likely to be taken up by the Supreme Court the following year.
There's some circuits that like to experiment more than others, aren't there, Sarah?
There are. Hi, Ninth Circuit.
Yes. Okay, so maybe we can try to do 2 more questions if that works for you. Wonderful. Okay, so one that came in, there's been a lot of talk recently about expanding the Supreme Court. What are your thoughts on this and how it would impact the court and government?
Yeah, that'll be a mess. There's not like one idea on expanding the court. It sounds really easy, right? You just add 2 seats and we'll call it a day. So we actually did have different numbers of justices on the court in the 19th century. In fact, at some points we had even numbers of justices on the court. You can see why that would be kind of a disaster if you have just a 4-4 opinion. And by the way, we do have that on our court now. When Justice Scalia died, for instance, we had a sudden vacancy on the court. It couldn't get filled right away. And we did have 4-4 decisions that would then, sometimes that's just the way it goes and the court just lives with a 4-4 decision. Other times it just gets heard the next year. So here are some of the ideas. You could just add 2 seats, but then what prevents someone, in the next administration from adding 2 seats and all of a sudden we have a 30-person Supreme Court? I think that would
all going to be Supreme Court justices, right?
That's right. And the reason that's bad, by the way, is not just intuitively, but I think you would pretty quickly end up with a very partisan Supreme Court that would lose a lot of its moral authority. We talked about Chief Justice Roberts as the institutionalist. Part of that institution is maintaining credibility. The Supreme Court, as the Federalist Papers say, has neither force nor whatever it is. It has will and judgment. It has no army. So when the Supreme Court says something, the only reason that matters is because we as citizens accept what the Supreme Court says. As you get to 30 people, we're going to be less likely to accept it because we're going to see it as more political and less judicial. Okay, so another idea was you could set term limits on the justices and then say that basically from that point forward, every 2 years we would add a justice so that by the time you get through that, eventually you end up back with 9 justices, but that every president gets to appoint 2 justices during their term. Not crazy.
It seems complicated.
It's a little complicated to get there. It will take about 18 years to get there. And then I think you still end up with this really partisan problem. Yes, you still have 9 justices, but when they know they're on term limits, I don't know. That one to me is more reasonable, but there's a lot of unintended consequences of screwing around with our system. So I'm pretty Burkean about these things, meaning that, if it ain't broke, don't fix it. I don't think it's broke. And I think the Chief Justice kind of proves that point. I think the fact that Justice Gorsuch was in the liberal majority on the Bostock opinion proves that point. I think we're a long way from a broken Supreme Court, even if you don't like the outcomes of individual cases. So don't mess with it. That's my vote.
Thank you. And last question is, in the age of the pandemic, how has COVID impacted the court?
Yeah, so it was actually really fun for people like me who follow the court closely because they canceled the May and April term. They punted a lot of those cases just off their docket or to the fall, or they decided it just on the briefs. But they then held a May term really late, and they did it by telephone. This was super fun because up to this point, there's no cameras in the Supreme Court. The audio is usually put out 24 to 48 hours later. And that's sort of a bummer because unless you happen to live in DC and if you're a lawyer admitted to the Supreme Court, you get sort of priority seating. But otherwise, it's actually pretty hard to see a Supreme Court argument live. Not to mention, what if you just have something to do that day? So because the justices were social distancing, they held their arguments teleconference, and anyone could listen to that teleconference. It was awesome. It did change the way the questions worked, though. So normally, if you've ever heard a normal Supreme Court argument, it's a free-for-all. You're standing there as the advocate at the podium, and there's 9 people, and they can all ask questions. There's courtesy, where a more senior justice can basically step on a more junior justice and have their question answered first, or just interrupt the more junior justice. All of that's sort of fair play. In the teleconference, the way they did it was the Chief Justice went in seniority order, and you got to ask your question for 3 minutes or so, and then it moved on to the next justice. So there was no crosstalk, there was no follow-up questions, which a lot of people were disappointed about. But the argument time lasted a lot longer. Normally, they're an hour, and these were lasting for an hour and a half sometimes, which I loved. Wow. Because you just got to hear a lot more from the advocates. I felt like the justices' questions were less, I call it ping-ponging, where basically they know the outcome that they want already, that they're going to vote for. And so they're using the advocate to try to persuade someone else down the bench. But instead, because they were always going to go in a set order, they were actually asking real questions that they had about the case. They were tough on both advocates. So it was much harder to determine where everyone's vote was going to fall out, which I enjoyed. And also, Justice Thomas, who asked about, one question every 10 years, asked questions in all of the cases, which was really, really a treat for those who like the Supreme Court.
And it is clear that you do, Sarah.
I do. It's true.
Well, thank you so much for joining us today. It's been a pleasure to have you on. And hopefully we will talk to you again after the next set of cases come down. So thank you so much, Sarah.
Love to. Bye.
Bye.